information about what's coming out of the Supreme Court. There's been a lot of great news, some things to celebrate, and also there are court cases that I don't know about, and I'm sure you also probably don't know about them either. So this is part of our effort to really break down what's happening and inform you. Part of Manny's mission is to create a better informed public, and so this conversation today is going to be with someone who's at the center of this, who really understands and can break down what's going on. So one thing I just want to say is we have been having some technical issues kind of in the lead up to this, so we may at some point, if there's issues with the live stream, just temporarily shut it down and join it on Zoom. We're dealing with a lot of different kinds of cameras here out of Manny's, and so just be prepared for that. I may make the decision at some point, if people are having trouble hearing or we have issues with the camera, to actually just go right into Zoom. So with that said, I'm just going to do a quick check-in with the team. Team, how is it coming through on the live stream? Great. Awesome. And can you hear me, Ben?
I sure can.
Fabulous. Okay, so Ben, the person that we've brought here, has spoken at Manny's before and is a repeat offender on the Manny's circuit. He's the chairman of the California Appellate Law Group, and you have been deemed as one of the top litigators, appellate litigators in California. So really excited to talk to someone who is such an esteemed lawyer and also understands how this whole appellate system works. And so thank you, Ben, for coming here tonight, at least digitally. I appreciate it. And so I wanted to start by asking you some general questions. First, about what is the appellate system and what does it mean to be an appellate lawyer, and how does that connect to the Supreme Court?
Yeah, so in the legal system, there are 3 levels of courts usually. There's a trial court where people have trials in front of juries. The judge who bangs on the gavel, objection, Your Honor, all of those things. Those happen in the trial courts. At the federal level, we call that the district court, and at the state level, we call it the superior court. If you don't like what happens in the trial court, you can appeal. That's where I appeal, and that's where you go to a second court that usually has 3 judges, and they hear legal questions, and they decide the questions in the appeal. And if you don't like what the appellate court has done, you have the option of asking the Supreme Court to weigh in and decide your case. The Supreme Court decides only a few cases a year, but what the Supreme Court decides ends up being the law of the land.
Got it. Thank you for explaining that to me. We have a lot to cover. I have this cute little piece of paper over here with all the court cases that we're going to try to get through today. It's been a big session. There's been a lot of big court cases. Before we actually get into these specific court cases, Ben, can you tell us a little bit about, and you and I talked earlier today about this, kind of how the Supreme Court makes these decisions and the kind of the confusion around liberal versus conservative and partisan, Republican appointee versus Democratic appointee, and maybe how we kind of may have seen a little bit of that in this year's session.
Yeah, so the Supreme Court is made up of 9 justices. Each of those justices are appointed for life. They're nominated by the president and confirmed by the Senate. Currently, there are 5 justices who are appointed by Republican presidents and 4 justices who are appointed by Democratic presidents. As we'll learn today, as we talk about the cases from this term, that doesn't always mean they come out in favor of what you might think of as the Democratic answer, or you might think of as the Republican answer. But those are their general leanings tend to be in those directions. So this is what we call a conservative court. The Chief Justice of the Supreme Court is named John Roberts. You've probably heard of him. Some of the justices that were nominated by Democratic presidents are Ruth Bader Ginsburg and Sonia Sotomayor. From Republican presidents, you have people like Clarence Thomas and Brett Kavanaugh.
I think my personal favorite would be Sonia Sotomayor, just because I actually got to meet her. She was in San Francisco in 2010, I think it was, 2012, right before a couple months before they ruled on in 2013 on the Supreme Court case. So she was here for her book tour, My Beloved World, and I got to meet her. And as she was signing my book, I said, I want to be able to get married one day. And then stared right at her, and she said, I'm going to do what she said, thank you. And because she couldn't say, I got you. Right. But she looked right at me and she said, thank you. And so I feel like we had that same-sex marriage connection, the two of us.
Yes, Sonia Sotomayor is probably the justice most furthest on the left on the Supreme Court. She's also the justice with the most. Kind of justice. Yeah, she's also the only justice who is not a millionaire, pretty much, or close to being a millionaire. Her assets had her almost normal, but the other
Wow.
justices are very wealthy for
Got
the
it.
most part. Yeah.
Okay, so thank you for that breakdown, Ben Feuer, our expert. Well, let's get into these cases. But before we do, like, general, are we like a thumbs up, a thumbs middle, or a thumbs down? Let's presume that you're a liberal, like me, and probably a lot of our audience. Would you give the decisions made like a big thumbs up, a medium thumbs up, a thumbs middle, or a thumbs down on these decisions?
So what I would say is, compared to the way the term could have gone, it's a thumbs up.
Okay.
That is, by and large, the Supreme Court had opportunities, a number of opportunities to issue very conservative opinions, and it didn't. Most of the opinions were relatively middle of the road. Some even went to the left in terms of outcome. And the ones that went to the right did so in small steps instead of giant leaps. And so if you're coming at this from the perspective of someone who is looking for liberal left-leaning outcomes, this term got you some good wins and some not terrible losses, especially considering it's 5-4 Republican Democratic appointees.
Got it. Okay, so are we ready to get into it? Can we
Sure,
start
let's get into
talking about these?
Yeah.
All right, so for each of these cases, I'm going to ask you to help explain what the case was about, who voted what, and then kind of what does it all mean. So let's start with the case that made a lot of news today, Trump versus Meszaros / Deutsche Bank / Vance. This made a lot of news today, and this is a case involving our dear President Donald Trump. This case? Our dear President. What was this case about? Who voted what, and what does it mean?
Yeah, so this case came out today. It was a big deal in the news today. This morning at 10 a.m. This was, in my opinion, one of the very most important cases of the term. The result was somewhat disappointing, and I'll explain why, but it wasn't as bad as it maybe could have been. So this is really two cases. One is Trump against Meszaros and Deutsche Bank. Meszaros is Trump's accounting firm. Deutsche Bank is his bank. And this is a case brought on behalf of the House of Representatives in Congress, who have sought a subpoena to Deutsche Bank and Meszaros, not to Trump himself, but to his bank and to his accounting firm, for copies of his tax returns and some of his other financial documents. And Trump challenged that subpoena and said, hey, I'm the president. I'm a victim here. They're just coming after me. They don't get to have this. It's a vendetta. You know, it's fixed. The usual Trump, rant stuff, right? Historically, Congress has really broad power to issue subpoenas for documents and testimony. You can think of this before you're in my time, but during the Nixon administration, you may remember learning, had these recordings of conversations in the White House.
Yes, actually, brief pause on that. I went to high school with H.H.R. Haldeman's grandson.
Oh, wow. Yeah.
And so I learned about U.S. history and about the Nixon era with Haldeman's grandson literally sitting next to me in history class. It was a little awkward.
Wow.
Yeah.
Wow. Yeah. Right. No, that's.
He was in the room.
Yeah. No. And so Nixon.
He also said some pretty uncouth things about our people, Ben, if I remember correctly. The Jewish people.
Yeah, so this was one of the problems with these tapes that Nixon had. Nixon was keeping tapes of his White House conversations where he basically planned the Watergate break-in and also said nasty things about every minority you can imagine, including Jews. And the Supreme Court said, hey, Congress has issued a subpoena for that. They were trying to impeach Nixon. They had subpoenaed these tapes once they learned they existed. And the Supreme Court said, Nixon, you got to turn them over. And he did. He complied with what the Supreme Court said. And once those tapes were out there and people heard what he was saying behind closed doors, that was it. He was done. He was done.
So Trump did not want to give his financial records away. And did the Supreme Court decide that he had to show his financial records?
Well, the Supreme Court decided a mixed opinion. The Supreme Court said, look, yes, the president does have to give his financial records, but he only has to do it when it meets a number of conditions. The documents have to be really necessary to a legislative purpose that Congress is doing. Now, Congress said, hey, look, we want to make sure the president isn't corrupt. We want to make sure we have good laws about money laundering because we think this guy might be laundering money. And so we want to see what his financial records said. But they didn't really look at that closely. They basically said this has to go back to a lower court, which has to make sure that this is really a legitimate subpoena for a legitimate reason that's not really imposing a burden on Trump. Now, this will go back to the lower court. I think the lower court will very likely approve the subpoena. This is a very minor subpoena. It's not even going to Trump, it's to his bank. It really should be approved, but it won't happen. And this is why it's a real mixed opinion. It won't happen until after the election. And that's really all Trump cares about. Trump doesn't want this getting out. The fact that, guess what, whatever scam he might be up to that might be reflected in his tax returns, right? He doesn't want that getting out before the election. And now it won't. It's got to go through some more steps. If he's reelected, different issue. If he's not reelected, the House may not care about his financial records anymore. So the Supreme Court punted. Now, the other part of this is, again, with Vance, Trump against Vance. This was a different subpoena from a grand jury in New York State that is investigating Trump for violating state crimes. Cyrus Vance is the district attorney in Manhattan, and he thinks Trump is engaged in who knows what. And, so he wants Trump's financial records for that reason. The Supreme Court said, these you have to turn over, but we're also going to send these back to the lower court, make sure there's a proper purpose, essentially putting it off until after the election takes place. Got it.
Okay, so let's move on to the next case. Our Lady of Guadalupe School versus Morrissey Beru. This case, obviously something very interesting and important. And can you tell us about what Our Lady Guadalupe School was about and what was the decision? How did people vote? And what does it mean, Ben?
Yeah, so I'll talk about that. But one of the reasons I wanted to talk about this next is one thing from the Trump cases that I sort of didn't mention. And that's that both of those cases, the subpoenas for Trump, were decided 7-2 with John Roberts writing the opinion. John Roberts appointed by George Bush, a Republican, and he had Brett Kavanaugh join and Neel Gorsuch. They all joined in those opinions that will eventually force Trump to turn over his tax returns. Controversial issue. So it wasn't 5-4. This other case, this next case, Our Lady of Guadalupe School against Morrissey Beru, was also not 5-4. This is another controversial case. It was also 7-2, although this one was written by Sam Alito and the dissenting justices were on the left. This is a case about whether anti-discrimination laws apply to religious institutions, particularly religious schools. Because there are a lot of religious schools that employ a lot of people who aren't priests or preachers or rabbis or ministers. You got the teachers, you got the janitors, you got the coaches, you got the guy who runs the computer system.
Right.
Now, traditionally, historically, the Supreme Court has said, look, if you're a minister or a priest, the church, because we have the First Amendment, it protects religious liberty, the church gets to decide whether they want somebody, whoever that person is, to be the person who's preaching their religion. Maybe that church doesn't like black people. Maybe that church doesn't like old people. Well, the church gets to decide who its ministers are going to be. We're not going to go in and say all these anti-discrimination laws actually tell you who your minister can or can't be. But non-ministers, the other people who work for your company, a corporation that essentially all religions are, those people they're just employees. They are protected by the laws. You can't fire them if they're black. You can't fire them just because they got old. You can't fire them because you don't like women. You don't want women working there, and all the other protections that those folks get. So this case was about who gets to decide who ministers are and who ministers aren't. So this case was brought by two Los Angeles fifth grade teachers.
Wow.
Fifth grade teachers, right?
Fifth grade teachers brought this case. Wow.
They did, yeah. And one said, hey, I was fired because I got too old. And the other one got cancer and was fired. And they both worked for basically Catholic schools. And so they said, hey, we're just teachers. We're not ministers. I'm not teaching religion. I teach science. I teach math. And the school said, look, anybody who's out there in a position of authority in our school is to us a minister, and therefore we want to decide who our ministers are. That maybe they include our teachers, maybe they include our janitors, maybe they include our computer people. And the Supreme Court agreed with them, agreed with the school, and said that, look, if you're a Catholic school or a religious organization and you want to say that your janitors count as ministers, well, then you can fire them for reasons that you otherwise wouldn't be able to fire someone in a normal job because of their race.
Okay, so that's a bummer. And do you think this is going to open up future future cases that allow folks to discriminate against people for religious exemptions?
Certainly in religious areas, that's a risk, right? For religious schools or religious organizations, it's a real risk that will be expanded. And those religious groups will say, hey, this person's a minister, that person's a minister, and I can do whatever I want with them. But it's a big deal in Catholic schools. Now, and then again, another thing that's important to recognize, 7-2 opinion. Ginsburg went along with it. Breyer went along with it. So, it's important to recognize.
Why do you think Ginsburg went along with allowing religious schools to discriminate against people?
Well, you have to look at it also, and this is the case, I think, with many Supreme Court cases. There really are good arguments and good reasons for both sides. And it's really important to kind of recognize that. The other side of it is, hey, why shouldn't a religion get to decide who the people who speak for its religion are? Right? If you don't want to abide by whatever Catholics believe or whatever some other religion believes, look, go work for a public school or go work for a secular private school. Don't work for the religious school in the first place.
I see, and I think that I understand now why you put Bostock versus Clayton County next, because a lot of people don't realize that maybe doesn't change the religious exemption. Is that why you did that?
Yes, that's exactly right.
So we're on the same page. I see what you were doing there. Okay, so let's go to, I think, my favorite case of the Supreme Court term, which protects LGBT people from being fired in their jobs, right, Ben?
Right, but not if you're working for a religious organization.
Exactly.
School, as we learned from the previous case.
Which
but
a
you're
lot of
right.
people didn't realize.
If you work in a non-religious school, as the vast majority of people obviously do, then good news, even in states that don't have their own protection against sexual orientation discrimination, which California does. So this case didn't really affect you and me or people in California because we already have these protections. But only about half the states have those protections. And Georgia is not one of those states. So Georgia is only, people employed in Georgia are only protected by the Federal Civil Rights Act of 1964, which was a time long before anyone was really thinking about protecting gays and lesbians, right? Or people, or individuals who are transgender. This, here's some paper tearing. Which this,
that was me. I'm writing a note.
Also protects. So this is a guy in Georgia who had been a county clerk for a long time. And then after 20 years, someone in the county clerk's office, I think your microphone might be pretty close to where you're writing, Manny, because it's coming in pretty loudly. That's okay. So this is a guy who was a county clerk in Georgia, and he had been there for 20 years. And then someone realized, hey, I think this guy's gay. We better fire him. So that's what you do, I guess, in Clayton County, Georgia. So they did. So they fired this guy in Clayton County entirely because he was gay, which you're allowed to do under Georgia state law. And he brought this lawsuit, and there were a few other lawsuits that were consolidated, saying, hey, wait a minute. This isn't really sexual orientation discrimination. It's not really that they're discriminating against me because I'm gay. It's really that they're discriminating against me based on my gender. They're discriminating against me because I'm a man, and I'm a man who has sex with other men and likes to have relationships with other men. Because if I were a woman who liked to do that, they wouldn't have any problem with me. I would get to keep my job. So the only difference between me and someone who gets to keep my job is our gender or our sex, which is the term that was used in the statute at the time, and that's prohibited. You can't do that. So this case came out 6-3, much to, I think, a lot of people's surprise, including myself, in favor of Mr. Bostock, and where the court said, yeah, that's right. The only thing separating you from the person who gets to keep their job is that you're a man and she's a woman. And it's the same thing if you like to wear women's clothing. The only thing, if the employer says, look, a woman who wears women's clothing, that's fine. But a man who wears women's clothing, that's not fine. That's discrimination on the basis of sex. Now, this is a really, really interesting opinion for a lot of reasons. And did you have a question?
Yes. So two things. One is the reason they said it was not okay because they're basically expanding the definition of sex to include sexual orientation and gender identity?
No. And I think it's really important to recognize that. That is not what this opinion
Oh, that's what I thought.
Okay, yeah,
so
that's what a lot of people
thought.
Then? That's what the sort of was reported in the news media, and this is really important to understand, I think. What they said is that this is just gender discrimination. You're discriminating against someone just because of their gender. It doesn't matter. All you're saying is that, look, you Manny, like perhaps, guys, but if Fanny, your sister,
a definite yes.
Definitely yes. If Fanny, your sister, likes guys, she gets to keep her job, but you, Manny, don't get to keep your job because you like guys. The only difference between you and Fanny is your gender. And so that's gender discrimination.
I see what it is.
It's a very clever argument. And that's one of the reasons that the writer of this opinion was, again, much to everyone's shock, Neel Gorsuch. One of Donald Trump's very conservative appointees. And Gorsuch is what we call a textualist. Gorsuch believes that the way you should interpret the law is by looking directly at what the text says, not thinking about what the outcome is, not thinking about what the people who wrote it intended, because there's no question that in 1964, Congress did not intend to protect gays and lesbians. It was still illegal, I think, at the time, right? You'd go to jail at the time. And, this was a long time ago. And so Congress was not intending to protect gays and lesbians. But the way it's written, it protects gender. And if the reason you're treating two people differently is just because of their gender, that's illegal under federal law.
I get it. And were you were surprised that Neel Gorsuch sided with the majority? Were you surprised that Chief Justice John Roberts also sided with this? And do you think that this means that further LGBT rights cases are going to be seen more favorably by this court than we may have thought?
I was surprised that I was impressed, shall I say, that Gorsuch, who had always said he's a textualist, really stuck to being a textualist. And he did that a couple of times this term, where he really focused on the reasoning behind getting to the answer and not what the answer ultimately is. And I think that that's so important for our justices of the Supreme Court to have credibility by saying, look, all we're doing is interpreting the law in a certain way. We're not focusing on what the outcome is. Right.
Okay. So quick interruption. I have a quick pop quiz interruption. If you had to get a beer with Neel Gorsuch or Chief Justice John Roberts, which one would you get a beer with?
They would both be fascinating. I think the most interesting person probably on the Supreme Court to get a beer with would be Elena Kagan.
That was one of my options. Neel Gorsuch or John Roberts.
I did the lawyer thing where I took your question and just made it my own question and answered what I wanted to.
Would you rather get a beer with, John Roberts or Neel Gorsuch?
I think I'd be equal. I mean, I'd be down with a beer with either one. That's
okay. Now, if you had to be stuck on a desert island with Elena Kagan or Clarence Thomas, who would you rather be stuck on a desert island with?
Elena Kagan, hands down.
Got it. She seems like she'd figure it out. Okay, let's go to Oklahoma.
Can we
talk about Oklahoma for a second, Ben? Oh my God.
Yeah, let's do that. But just before we get to that, let's talk about two really important things about the Bostock opinion. Which are in terms of how what the effects, and you asked about this, what the effects of this opinion might ultimately be, because they may go in different directions than people are feeling right now because of the reasoning behind it. What the court did in this case is it basically said, look, if you are treating two people differently for any reason in the same instance, and the only difference between them is their gender, and that's the only reason you're treating them differently, and that's illegal. And that has already had one effect, and I think there's a risk it'll have another big effect. The effect it's already already had, which a lot of people maybe didn't expect, is Harvard University had instituted a policy a couple of years ago that punished anybody who joined a single-sex organization off campus, like a fraternity or sorority. Harvard said, look, we don't want our people in those. We can only control what goes on campus. But if you join an off-campus fraternity and it's only men, or an off-campus sorority and it's only women, we're going to punish you because we think that that's wrong, and we don't think that a Harvard person should do that, right?
Okay.
After this opinion in Bostock came out, Harvard reversed course and said, we now think that that would be unconstitutional. The policy we were going to put in, unconstitutional under Bostock. Because the only difference, what Harvard said is, under the reasoning of Bostock, the only difference between, we wouldn't punish a woman who joined an all-male organization, because that organization would no longer be all-male. And we wouldn't punish a man who joined an all-female organization, because that organization would no longer be all-female. It would be co-ed. And so if the only difference between the people doing those things is their gender, we think that under Bostock, there's a real risk that that would be found unlawful. The other big effect I want to kind of put on your radar is what this might mean for affirmative action. Californians are going to be voting in the next election. One of the ballot measures is going to be whether to reinstate affirmative action, which is a form of what they call positive discrimination. We're going to give extra points to somebody based on nothing more than their race or gender. And then there's something on the ballot to reinstate that at the University of California and in other ways in California. Whether affirmative action can survive this analysis is perhaps really questionable, because if you're treating one person in the exact same situation, if Manny gets into Berkeley and
I'm like, where are you going to
Jamal
put me?
doesn't, and
What
the only
college am I
difference
getting
between
into?
Manny and Jamal is race, that could be a real problem under Bostock.
So this
Or
case
the other way
could have-
around.
This case could unintentionally, the decision in this case could have unintended consequences to affirmative action, is what you're saying.
Yeah, and I don't know that they're unintended either. I mean, the Justice Supreme Court are very smart. They know what they're doing. And so it may be that some people thought about this.
And the ability of Harvard bros to join all-male fraternities off campus if they want to. Got it.
They're going to get to keep doing that.
Let's go to Oklahoma.
Yeah.
I'm really excited about this. I had the honor of interning with President Obama's tribal liaison when I was a White House intern in the summer of 2011, Charles Galbraith, in the Office of Intergovernmental Affairs. And so I actually got to work on some tribal issues and Indian country, and there was a big water use and land use case that passed when I was there. I forget which one it was, but I was really excited to see this today, and it's such a huge win for the Native community. But in reading something about it, I also heard that the dissent was really concerned about criminal justice and being able to kind of operate a criminal justice system in Oklahoma. So can you tell us about Mcgirt versus Oklahoma? What does it mean? How is it decided? And what will it do to the future?
Yeah, so the reason I put this case next is because this decision was also written by Neel Gorsuch.
Neel
Gorsuch. It was also a very textualist decision. And in fact, it was a 5-4 decision with Gorsuch joining the 4 liberal justices to reach this result, which again, Trump's first appointee to replace Antonin Scalia, joining with the 4 liberals to say that basically the entire eastern half of Oklahoma, almost 2 million people, including the city of Tulsa, Oklahoma, are all on a Native American reservation.
Wait a second, hold up. So Tulsa is now considered an Indian reservation? That's considered tribal land?
Is now on an Indian reservation. Yeah, Tulsa, Oklahoma.
Does that mean there's tribal sovereignty? So like the government of Tulsa has to like
only over
be superseded
Indian.
by the
So I mean, a couple of things to think about to understand about
so
this
many
particular
questions.
treaty. Yeah, so it's only over Indians in that area, right? And people of Native American descent and the tribe, right? So that's the first thing to recognize. But yes, the state of Oklahoma no longer has jurisdiction over the lives and behavior of people of Native American descent who live in the eastern half of the state, including.
Wait, but I thought tribal land was like they had their own rights to like basically the American government couldn't tell could not legislate what's happening in tribal land. I thought they had some kind of legal sovereignty. Do they or don't they?
They have some sovereignty. They have sovereignty from the state government, but they don't have sovereignty of the federal government. And the particular details of the sovereignty can be different from tribe to tribe and reservation to reservation, depending on the treaty that the government signed, generally in the 1800s, with whatever Indian tribe that was. So here, the Native American tribes are going to have jurisdiction over Indians along with the federal government. So the federal government will also have jurisdiction over Indians in that area, but the state government doesn't. It also is going to mean that the tribes probably have some more power over casinos in eastern Oklahoma, over alcohol sales in eastern Oklahoma, which are also historically decided by the states. And tribe members who live in this part of Oklahoma will no longer have to pay Oklahoma state taxes, which might be nice for them. But the federal government is also going to have control, and the tribal government is also going to have control over their lives. So this is this is a fascinating decision. I mean, the guy behind it, Jim C. Mcgirt, is a really bad guy. I mean, I think it's important to recognize that. He is a member of the Seminole tribe, but he was convicted of the forcible rape, molestation, and sodomy of a 4-year-old girl.
Oh my God!
And he was sentenced to 1,000 years in prison.
Oh my God!
Under Oklahoma law. He served
Mcgirt.
Not a nice guy, Mcgirt.
Not a nice dude. Do not want to get a beer with Mcgirt, that's for sure.
Not a nice dude. Yeah, but his case in the Supreme Court didn't even challenge. He didn't say I'm innocent of the rape and all that terrible stuff.
Goodness.
He just said, look, the state of Oklahoma doesn't have authority to prosecute me for this. The only people who have authority to do it are the federal government or the tribal government. And this is going to result in hundreds, if not thousands, of people convicted of crimes of Indian descent in Oklahoma of being let go. Now, the federal government may be able to prosecute them again, depending. Maybe the tribal government can do it, but it is going to cause a pretty significant effect to criminal justice, just like the dissent said. So, other people who have done what this guy did may get let go, but Gorsuch, again, a textualist, isn't looking at the result. And he's not looking what was intended by Congress or what Congress thought it was doing. He's looking only at the text. And what he said is, look, Congress ceded this land to the Creek tribe, although now 5 tribes occupy the land. And Congress never explicitly took that away.
Okay, so just to be clear, it's if you believe in increased tribal sovereignty over land that is rightfully theirs, this is good because it gives more land back to tribes. And at the same time, there could be an unintended consequence of folks who are of tribal descent who previously said they could, who would have been able to be tried for crimes they committed. Now they will either be let go or not tried for crimes because the state doesn't have authority over them anymore.
Yeah, or people who are convicted. Yeah, or people who are convicted.
They can be let go.
Yeah, exactly. I mean, people they could be let go, or there are going to be bad people who are going to get out, but that's the result of the law.
Okay, so now we're in the low point, I guess. So let's go to Little Sisters of the Poor versus PA. This was this is a good one, right? This is a birth control one.
No, no.
No? Okay, so
no, I mean, it is a birth control one, but it's not a good one.
Abortion's good. Abortion's good. Yeah. Birth control bad. This is the one that made it so that employers can stop giving their employees birth control if they don't want to, right?
Yeah, we're in the low one. This case and the next case are both kind of bummers. But that's exactly right. You said it exactly right. This is a case where the Supreme Court held that, look, under Obamacare. So Obamacare says insurers have to cover medicines that are necessary to protect women's health. What those medicines are, those are left to administrative agencies to define. But the law says medicines that protect women's health. The Obama administration defined that to include contraception. This led to some lawsuits. You remember a few years ago, Hobby Lobby, that big company run by
everyone's
religious folks. They took a case to the Supreme Court and said, hey, we're a private company. Our owners really believe contraception is wrong, and we don't want to have to pay for insurance for that. And so the Supreme Court said, okay, private companies, if the owners really have a genuinely held religious belief that something's wrong, they don't have to pay for the insurance to cover that. Okay. So,
Got it. Because companies are people, right? And people have protected. That was the whole like Citizens United decision where
or something, yeah. I mean, there was an
they treat
element of that.
companies like people, and people have protection, so we should protect companies.
Yeah, I mean, it wasn't exactly like that. I mean, it wasn't based on the idea that a corporation is a person, but it was based on the idea that, hey, the people who own corporations are people. They have rights, and it's their corporation. They can decide what to do with it.
Okay.
So, I don't know that I thought it was a particularly well-reasoned decision, but that was the decision. So this case is about everybody, all the other companies out there, because when Trump came into office, one of the first things he had his administrative agencies do is redefine the rules of what counts as a medicine necessary to protect women's health. And lo and behold, it didn't include contraception.
Got it.
So, but he went through the process to do it. And the Supreme Court said, look, you went through the right process to do it. Now, if, companies don't want to cover it or insurance don't want to cover it, then, they don't have to because you've gone through the right steps to do it. And, especially if you have and the Trump rules basically said if you have a religious, the exception was for a religion. If you have a conscience exception, if your conscience opposes contraception, you don't have to cover it. And the Supreme Court said, okay.
Understood. Okay. Yes, and anytime you need to take water, drink, feel comfortable. I know we're asking a lot of questions and there's a lot of information here, so I appreciate it.
No.
Okay, shall we move to Espinoza versus Montana Department of Revenue?
Sure. This is another case that's a bummer.
This is the state funding of religious private schools.
Yeah, this is
a lot of cases about schools and what schools can do and what people with different religious views can do. Is it typical for the Supreme Court to have this many cases about religious exemptions, religious discriminations, schooling, that kind of thing? Is this typical to have this many cases like this?
The terrific question.
Thank
you. Answer is all your questions are terrific, man. They're all great.
Ben.
The answer is yes and no. The reason, so the Supreme Court tends to take cases in a bunch. Each term they kind of decide there are a couple issues they really want to focus on. So they may take a few cases on that issue. Maybe it's religion this year, maybe next year it's, Indian law, or whatever it is. And so they tend to do that. It's also true that this Supreme Court has been especially focused on religious liberty. Religion, it's for the Roberts Court, is really important. He thinks many on the court think that there's been discrimination against religion and religion in general. Now, the Supreme Court's religious makeup is absolutely fascinating. And this is really, and it may inform all these cases. And in fact, it's something that we can, we're going to talk about shortly. So I'll talk about it at the end of talking about this.
Let's do it. Definitely.
Okay,
and I don't want to leave our friend Brett Kavanaugh, who is probably my least favorite person ever, out of this conversation. So if there are things that Brett Kavanaugh has done, or maybe we can talk about him at the end, maybe save the worst for last.
Sure. Yeah.
So let's talk about Espinoza. Yeah.
Written by John Roberts. And this is about a program set up in Montana and many other states that gives vouchers and other tax reimbursements to parents who send their kids to private school. It's part of the school choice movement, which is popular basically with conservatives, very conservative individuals, and inner city blacks are very supportive demographic in the polls of these programs because they can get their kids out of the local schools, which tend not to be very good.
Did you go to a religious school or a private school? A religious private school?
I went to school with you were telling me who you went to school with Haldeman's kid.
I went to yeshiva.
I went to school with Kobe Bryant, actually. He was 2 years ahead of me. I like to say I taught him everything he knows.
How about that?
Got a little sad, except the rape. That was the joke that I made. Of course, now it's all terrible and sad. And he was an incredible basketball player, but he was 2 years ahead of me.
Wow.
But so this is a program in Montana that had that would give vouchers and reimbursements to parents who sent their kids to private schools, except if you sent your kid to a religious school. Then you didn't get a reimbursement or a tax deduction. And that's because there was an amendment to the Constitution of the state of Montana called a Blaine Amendment. 38 states have a Blaine Amendment, and it strictly prohibits any expenditure of state funds to support any religion or religious exercise, okay?
Okay.
Simple enough, separation of church and state. The reality is a lot trickier. Blaine was a congressman in the mid-1870s. He wanted an amendment like this as part of the federal constitution couldn't get it, but he inspired a lot of states. The reality of the Blaine Amendments is that they didn't really arise from this grand idea that government and religion should be completely separate. Rather, here's a question for you. What minority in the United States was growing rapidly after the Civil War and was deeply mistrusted and discriminated against, and also ran a lot of its own private schools?
Was it the Jews?
It was not the Jews. It was the Catholics.
The Catholics?
Deeply, deeply loathed and mistrusted in the
it.
United States, really up until the 1960s.
Right,
and so
until Kennedy, right?
Really until Kennedy. I mean, a lot of people didn't think a Catholic could get elected president until JFK won. So these Blaine Amendments were really about Catholics and a desire to keep states from supporting or funding Catholic schools, because a lot of people went to Catholic schools. There are a lot of Catholic schools all over. Catholics run schools. It's a big thing in their faith. And so this was really about preventing Catholics from getting money. And so the real question in this case was whether these Blaine Amendments were constitutional. And the court said basically, no, they aren't. A state doesn't have to fund private schools. But if it does, it can't discriminate against religion. It can't say, we're going to fund all schools except religious schools and refuse to fund religious schools. Now, here's the question about religion. Does it matter, do you think, that Roberts, Kavanaugh, Alito, Thomas, Sotomayor, and maybe Neel Gorsuch are all Catholic? Supreme Court has 5, maybe 6 Catholics. Gorsuch was raised Catholic, but attends his wife's Episcopalian church. And 3 Jews. So there are no Protestants.
Can you believe that? There are 6 Catholics on the court. I mean, not that religion necessarily matters so much, but 6 Catholics, 3 Jews. I mean, this country was founded as a Protestant country. It's kind of...
It still is the majority of the country still is
Protestant,
right?
We should have a whole nother session about the makeup of the Supreme Court and why it is what it is.
Yeah,
that's interesting.
Yeah. So
okay, let's keep moving because there's so much more to talk about. And I want to get to more if we can. It's like eating at a legal buffet. You want to eat enough so that you're full. Maybe you have a little bit of a stomach ache, but you don't want to have too much. So it's like, that's what it is. Okay, so let's go to June Medical Services versus Russo, the abortion restriction one. So this was the popsicle, not the poopsicle. This was the one where Texas was trying to make it even harder to get an abortion, and the justices were like, no, that's not okay. We got to protect this particular. We got to make it less difficult to get an abortion. Is that correct?
A little different. This was Louisiana, not Texas.
Louisiana, not
Texas. Yeah, but there's a reason you're
Texas?
thinking of Texas, and the reason you're thinking of Texas is 4 years ago, only 4 years ago, Texas had the exact same law thrown out by the Supreme Court.
Oh.
The law here, it would require abortion providers to have admitting privileges at a hospital within 30 miles. And the reality means that you'd basically be able to get an abortion at one clinic in the state, in the whole state.
Yeah. So why was it brought back to the Supreme Court if they just talked about it 4 years ago? Hello?
No, I think that what happened was Trump got elected. He put Kavanaugh and Gorsuch on the court, and a lot of states and anti-abortion folks said, hey, changing the makeup of the court, we're going to get Roe versus Wade overturned. We got 5-4 conservatives. Kennedy's gone. That jerk, Kennedy protected in many cases women's right to choose.
Little do they know that Neel Gorsuch is like our friend in hiding, right? Was he the one that did the...
In this case, it was John Roberts. This was a 5-4 decision with John Roberts writing.
John Roberts, okay.
And this is really, it was really kind of arrogant of Louisiana. Really put Roberts in a tough place. So, Kavanaugh got confirmed. Louisiana went past the exact same law the court had thrown out a few years ago. It's really taunting Roberts. Roberts really, the most important thing for John Roberts is that he doesn't want the Supreme Court to be seen as a political body where the justices just go with whatever their political party is and there's nothing else behind it and it's just politics. He really meant it, at least in his mind, when he said there are no Obama judges, there are no Trump judges, we're all federal judges.
Do you think, Ben, that he decided in the way he decided to send a message to people that he was not going to run a politicized court?
I think it's a combination of things. I think Roberts really believes in what's called stare decisis. That's the doctrine of the Supreme Court, which means that basically when the Supreme Court issues a decision, unless it really thinks the decision was really, really, really terribly wrong and horrible in every way, it's going to try to respect that decision. It's not going to reverse that decision without a lot of really careful thinking. And that's for a lot of reasons. I mean, that's the whole credibility of the court. That's how people know how to behave. They predict their behavior based on what the laws are. That's how the justices now know that the decisions they work hard to come to aren't just going to be tossed away when a new justice comes on the court. So I think John Roberts really believes in that. I think at the same time, he's also does not want the court to be seen as political. So I think that both of those issues, I mean, look, Roberts is an opponent. He does not like abortion. He's really Catholic. He was in the dissent in the case 4 years ago in the text. So it's really fascinating that in 4 years, he dissented from the rule, but here he wrote the opinion that upheld the previous decision. Because he said, look, we come to decisions, we don't just throw them out because we changed the court. Right. And, he did narrow the decision a little bit, but by and large, he kept it. And I think compared to how it could have gone, you have to consider it a win for liberals.
Got it. Okay, so we have a couple more, and Ben, I do want to get to a couple of them if we can. It is 6:45, so we've got about 15 minutes left, and I want to talk about faithless electors, Chiafalo versus Washington. I actually had to look up what a faithless elector was. It's such a beautiful term. I feel like it's coming out of Game of Thrones or something. But real quick, a faithless elector is someone basically who is supposed to, they have to basically support the candidate that wins, but they choose to basically vote their conscience even though they're supposed to support a certain candidate, right? Something like that?
We started 5 minutes late, by the way, so maybe we can push it out another.
Okay, fine. All right, we can. I'll think about it.
So as folks probably many know at this point, when you go out and vote in November for the president, you're not actually voting for the president directly. You're voting for a slate of what are called electors. Each state gets a few electors. This was part of when the Constitution was written. There are a lot of reasons that folks think the founders might have done it this way. One being that at the time it was hard to get votes and collect them easily. So what happens is you vote, the votes are counted. The state decides that, in almost all states, whoever wins the popular vote gets all of the state's electors. It doesn't have to be like that. There are a couple of states that actually divide up the electors based on the city and the region that you're in. But most of the states just give you all the electors. Now, and then in December, these guys go to Washington or get online, and they actually cast the votes for president. It favors smaller states over larger states. A lot of people think it's unfair for good reason, but it's the way it is. So
I'm sorry, pause. Has it always been like this?
It has been, ever since the founding of the Constitution. Some of the rules were changed a little bit in the late 1700s because when the Constitution was written, the framers didn't really foresee political parties. So it was originally the person who got the most votes was the president, and who got the second most votes was the vice president.
Right, the national public vote, right?
Right, and no, it wasn't a public vote. It was still electors. It was still the votes of electors, but it meant that the other side got the vice presidency. Right?
Yeah, that's how you got Lincoln and Johnson, right?
Yeah, so they hadn't predicted that people would run with tickets. So then they changed that shortly thereafter.
Okay.
As a ticket. But yes, this has basically been the way it's been since the beginning. And there's a lot of movement to try to change it, but the small states, why would it? It gives them more power, right?
Right.
But because you have people actually going to vote for you, there's this risk that, hey, what if someone who said they vote for Hillary Clinton actually goes and votes for Donald Trump for president at the Electoral College, which is the meeting of electors? That's a real risk. The parties usually choose the electors pretty carefully. They want people who are really committed, but there's no guarantee that they won't mess up or someone won't change their mind. And that's happened a few times, including in the last election. And now, most of the time, president wins by a pretty large margin, has a lot more electors than the other guy. But in 2000, for example, the 2000 election between Bush and Gore, there were only 4 electors that were different. It was 271 to 267. So, what if one of those electors had, or 4 of them had really just decided, hey, we really want Gore instead of Bush. And then they
there's nothing legally stopping them from doing that?
Well, the states have put in laws to try to stop them. Fines, prison time, other kinds of punishment. And that happened in 2016. A few electors in the state of Washington and a few others around the country actually did vote for somebody other than who they were pledged to vote for. In Washington, a couple of them voted for Colin Powell in the hope that maybe they convinced
That's
some
random.
kind of random, and their hope was that they would convince some Trump people to vote for Colin Powell, and then maybe Hillary would get in. It didn't work, and the state of Washington actually fined them $1,000 each.
Got
so
it.
they brought a legal challenge.
So
saying,
this,
"Hey, you can't do
yeah.
that." And the Supreme Court said, no, the states can. In fact, nothing in the Constitution that says the states can't punish so-called faithless electors, and so the states can. And that was a 9-0 decision.
Wow. Okay, so very clear decision on that one.
Yeah.
Let's go to Daca.
Daca.
Such an amazing case. So
Yeah.
great.
Yes
Tell
and
me
no.
this is no, God damn it. I feel like that's the theme of all this. There's some great, and there's also some. You're kind of. You're bringing me back down to earth. So what? So this decision, Department of Homeland Security versus the regents of the UC system, DACA. What did it decide, and what does it mean also for the future of the immigration reform advocacy movement? Do you think?
Yeah, so this is for the Deferred Action for Childhood Arrivals program. This is a program started by the Obama administration, which basically said, look, if you came over as a kid, grew up illegally, grew up here, you spent your whole life here, maybe your parents brought you over as a baby, you never got papers, but you lived here forever, you speak only English, you've gone to school here, maybe you're a doctor or a lawyer or a very outstanding member of the community, even though the law says you really need to be deported because you're not here legally, we are going to, as an administrative matter, decide to delay or defer any action on your case. We're just going to put it off indefinitely. And as a result, you're basically going to get to stay here. So it's interesting. That's probably the right result. And in fact, this program, this idea of allowing these people to stay in the United States is incredibly popular in both parties. 75% of Americans support this kind of rule. And Congress has on multiple occasions tried to actually change the law to mirror this. But Trump, who hates all immigrants, of course, has said he would veto or not allow those kinds of laws to become law. So as a result, you have this administrative program set up by the Obama administration, which really doesn't actually do what the law says. It's actually doing something that's opposite of what the law says. And that, that's kind of a problem. So the Trump administration came in and they came in like a bull in a china shop. They have no kind of respect for the law. They're not many of their folks were not sophisticated legal minds or sophisticated minds at all. And they came in.
That's some legal shade right there from Ben Fewer.
Yeah, that's bad, That's, so they came in and they just kind of said, hey, we're not going to do this DACA thing anymore. We're just going to deport you. Well, there's a law in the United States called the Administrative Procedure Act that basically sets out rules and procedures for how you go about winding down an administrative program. And there's a set of rules you have to follow, and you got to take those steps, and you got to do it, and that's just how it works. And the Trump administration didn't do that. So here in a 5-4 decision, John Roberts said, look, this DACA program, Roberts joining with the liberals. Again, John Roberts, conservative, Bush appointee, joining with the 4 liberals, say, look, this program may not be lawful, right? It does seem to be doing the opposite of what the law says. But there's a process you have to go through to shut it down. And you didn't go through that process.
You can't just say I don't like it. Right? Didn't you use the word capricious? You can't just capricious,
arbitrary and capricious.
Such a great word. I just want to use that more in my vocabulary if I can.
Yeah. Good legal word, arbitrary and capricious.
Right. Do you feel like some people are saying? Do you think that the Trump administration can get their act together and come up with a less capricious reason to end the DACA program and bring it back to the court in time for the November election, or you think it's kind of no? Okay.
No. So it all depends. So whether DACA survives all depends on whether or not Donald Trump is reelected. If he is reelected, he will absolutely go through the correct methods of shutting down this program.
So another reason to get out there and support.
Another reason, big reason, and the Supreme Court will approve it. It's not that this program's okay, it's that you have to go through the correct process to shut it down, and you didn't.
Right. Okay. Just one more thing on this, and this takes me back to 2013 with the same-sex marriage case. Don't you think it's kind of crazy how many of our civil rights and legal rights have rested on just one person's thinking. I mean, if you
Yes.
assume that all 9 Supreme Court justices are brilliant and have spent their whole lives devoted to the study of law in their own way, but really, sometimes, with Justice Kennedy and now with Justice John Roberts, these major civil rights decisions rest on one person's shoulders. I mean, what do you think that says about our legal system, and how does that make you feel? And I don't know, just wanted to bring it up.
It's such a perceptive and thoughtful question, Manny. It's exactly the right question. For a very long time, really since the 1960s, Americans have been turning to the courts to protect their basic civil rights, instead of doing it either by the people they're electing or by the people they're electing. I mean, that's really the people who should be protecting our civil rights. If they're really, really important civil rights, maybe you amend the Constitution or pass a law to make clear what those, what the rights are that we believe in. But yeah, you're 100% right. It really shouldn't be left to the courts to decide to protect, often on pretty weak constitutional grounds, to be completely honest. Some of our most basic fundamental rights that are really kind of intrinsic to who we are as individuals and as a people. And maybe that's because Democrats and people who lean Democrat don't vote. It's been long been said that if everyone in the United States voted, it would be an overwhelming Democratic majority every time.
Do you support compulsory voting like in Australia?
Well, I'm a little hesitant to support compulsory voting or anything like that. And that's largely because I know a lot of lunatics. I think we all know a lot of crazy people who I don't know if I want those people voting, but there are a lot of people who are really thoughtful and who really should be voting, who just they don't bother, they don't think it matters, they don't care. And as a result, you get not just bad presidents, not just bad senators, but you get bad local representatives, bad city councilmen, bad state representatives, who are the ones doing a lot of these terrible laws.
Right. Okay, let's move to absentee voting. Long name, but basically a bunch of different states sued and brought this case to the Supreme Court about basically, was it to force people to absentee vote or make it so that they're removing the ability to vote in person? What was this case and what did they decide?
Yeah, so this case and the next case, assuming we have time to talk about it, are actually cases that the Supreme Court didn't take, and that I still think it's important to talk about because they're cases that, for the reason that the Supreme Court didn't take them. So this is 3 cases: RNC against DNC, which was out of Wisconsin; In re State of Texas, which was out of Texas; and Merrill against the People First of Alabama, which is out of Alabama. In all of these states, because of the coronavirus, people were suing to generally to increase the amount of absentee voting that would be allowed, even when state law said otherwise. In Wisconsin, you may remember, because of coronavirus, people weren't even going to get their ballots until after the election took place. In Texas, absentee voting is only allowed for people over the age of 65. In Alabama, it's barely allowed at all. Now, there are a lot of reasons for this. Trump says, it's for voter fraud. It's definitely not voter fraud. There's almost no voter fraud in the United States. It would be extremely difficult to do so by absentee ballots. And the voter fraud there happens equally just about on Republican and Democratic sides. And it's tiny, infinitesimally a fraction of a tiny percent. So that's all nonsense. But if, as we were just talking about a second ago, the fewer people, Republicans vote in greater numbers as a percentage than Democrats do, right? The people who say, I want to vote for a Democrat, a lot of times don't even bother to show up. Whereas Republicans, maybe because they're older, maybe because they're richer, they say, I'm going to vote for Trump, and then they show up and actually vote for him.
Yeah,
so
which we need to change that.
Yeah, so Republicans, for a very long time, worked hard, quite frankly, to try to disincentivize people from voting, make it harder to vote, cut down on voting locations, reduce absentee ballots, do everything we can to make it so that it's harder to vote, so only our voters who are richer, whiter, and more sophisticated can vote. On the other side, Democrats have been saying more and more voting, that's better, we want voting, but also they want it because it helps Democrats, right? It's not just altruistic. It's not just that voting is good. It's voting is good, but it helps.
It is the right thing to do, and it's a good thing for us.
Exactly. That's exactly
right. Myself, I don't want to presume.
And so the Supreme Court, what's important here is the Supreme Court declined to review each of these cases. The Supreme Court left in place the restrictive state law during coronavirus over dissents and said, hey, look, things are happening fast on the ground. elections are mostly decided at the state level and figured out at the state level, we are not going to insert ourselves in these elections as much as possible.
Got it. Okay, so we are at time, but I just want to quickly give you one sentence to talk about South Bay United Pentecostal Church versus Newsom. This was the COVID-related restrictions on religious gatherings, and this decided that the governor could restrict religious gatherings because of COVID. That's correct?
Right. There's another case where the Supreme Court declined to take
Declined to take it.
Left in place a lower court Ninth Circuit order saying, look, it's okay for the governor to say you can't have big church gatherings, but still let people into grocery stores and other kinds of events, because churches are different and involve more interactions and more risks than some other things.
And the final case is Collar versus Kansas, which was basically saying that people could not use mental insanity as a defense in criminal law.
Yeah, so this is one I included only if we had time. So I'm going to take the fact that you mentioned
I wanted to mention because like, holy moly, that seems like a really important case. And for those of you who are joining the break room, Manny's break room, we're still going to do it. We're going to do it in like two minutes once this ends. So the Manny's break room is still happening for those viewers who are excited and chomping at the bit for it. So the Manny's break room is happening just in 2 or 3 minutes.
Yeah, so this is a case that the Supreme Court did take, and they said, look, Kansas and a few other states have passed these laws basically eliminating the defense of mental insanity. It usually has been at common law, at English common law, and historically it always was, look, if you don't know the difference between right and wrong, we're not going to hold you responsible. It's only fair to hold people criminally, you may get sent to a psychiatric hospital, but it's only fair to hold people criminally responsible if they know they were doing something wrong. Kansas said, no, we don't like that. We think that's letting people off the hook. We're only going to let you claim to be insane if you didn't know, if you were so insane that you didn't actually realize you were doing the thing that you did. So the difference is this. Traditionally, if you think God is talking to you through your dog, and your dog tells you to kill someone and you kill them because you think you're doing the right thing because your God dog told you to do it, you're insane. We're not going to prosecute you. We're going to lock you up in a padded room maybe, but we're not going to prosecute you and send you to jail. You did not know that what you were doing was wrong because you thought God told you to do it. In Kansas, you would go to jail. In Kansas, the only thing that would keep you from going to jail is if you thought the person you were killing was a dog and not a person. You'd have to be that crazy. Because you knew, even if God is talking you through the dog, you know that killing someone is wrong, versus if the person who you're killing is a dog, then you don't even know you're killing a person. What you hit the nail. What do you even need me for? You got it, buddy. Great. You nailed it. Okay, so we got to close this up. My brain hurts officially, but it's a good hurt. I feel like I've learned so much. And I have to tell you, Ben, even though, there are some unintended consequences with some of these cases, and they're not all as good as the media has reported, we were all, I think, expecting on the left this Supreme Court to be a lot more conservative in its rulings than it's been. So I have a little bit more faith in our legal system and in the Supreme Court than I did at the beginning of this term. And I guess I wanted to give you the final word. How did this term make you feel? And what is the final thing you want to leave our viewers with? Well, I think just as we started and just as you just expressed, that's exactly right. That if the potential of what the Supreme Court could have done with this term could have turned it into a big thumbs down for people, who lean to the left. But given what the Supreme Court actually did compared to what it could have done, you have to call it a thumbs up. Great. Well, thank you, Ben Feuer. For those who are interested in continuing the conversation, please do. I'm very excited for it. Please go to tinyurl.com/Manny's Break Room. The link is right underneath me right here, tinyurl.com/Manny's Break Room. You can log into it now. Sam, our trusty digital director, is going to be opening up the break room now to let you in. So it's tinyurl.com/Manny's Break Room. Also, if you are so inclined and you like this program and you want to support Manny's, you can go to tinyurl.com/supportmanny's and become a sponsor of Manny's, make a one-time donation. We are almost 100% relying on your donations and our sponsorships to keep this place going and keep this programming going. So please support us and become a sponsor. It's $36 a month, which is a lucky number. And you can go to tinyurl.com/supportmanny's to do just that.
I also want to thank Ben Fewer for his time. I know you're a busy man, and you're doing a lot of work, and so I really appreciate it. And before we close, two more things. I want to thank our team here. Michael, thank you for all of your help with these programs and your steadfast touch and your digital expertise. Thank you to Christian. Thank you to Sam and Jupiter and Ram in the team, and to everyone that's helping us out with what's going on, and Lila, of course, the incredible Lila. And on Tuesday, we have the first in our new series called The Biden Bunch, where we will be interviewing senior staff of Vice President Biden's campaign. Very lucky. I think we're the only organization that's being given access to do it. And on Tuesday, we'll be interviewing Biden's LGBTQ policy director, Reggie Greer. So it'll be the first in our series called The Biden Bunch. So if you want to learn more about who is running Vice President Biden's presidential campaign, you'll be able to meet them all here at Manny's. So thank you so much again, and go to the break room to keep the conversation going. tinyurl.com/Manny's Break Room. Thank you so much, Ben Fewer, and have a great night, everyone.